Hello, everyone, and welcome to our webinar today. Thank you for taking the time to join us, where we're talking about all of the employment law changes which have been rolled out since last year. So I can see lots of people signing in. We normally just give it a minute or so just to let more attendees join. And I can see lots of people joining. It's a very hot topic, the employment law changes that have been really coming into effect over the past 12 months. And there's a lot of hype about them. So there's quite a lot of interest. So hopefully we can unravel some of that mystery for you today. A couple of housekeeping. Firstly, the slides will be sent after the presentation. Just give it a day or so because normally we like to edit the recording. Speaking of, this is being recorded. So you don't need to take notes. You can listen very intently and then we'll send it off to you later and you can watch it in your spare time, as I know everyone likes to do. Any questions, you can pop in the Q&A section, which would be in your toolbar as part of your Zoom. And we'll do our best to try and get to them. We try and keep this to about 45 minutes so there's time for Q&A. If we do run out of time, then don't fret, you can still send through some questions to us and we'll do our best to answer them. We have the wonderful Olivia from our team who's in the background helping out with the questions. So she'll try and answer any of them that she can in the Q&A. Otherwise, we'll answer them live. So just big thank you to Olivia, who's been instrumental in assisting Joey and I with research and prep for today. So thanks, Olivia. All right, so we might get started. So for those of you who don't know me, I'm Sarah Capello. I'm a partner in our workplace relations team in our Hunt and Hunt Sydney office. And I have with me here today, Joey Tass, who's my right-hand guy, and he's a senior associate in our team. Hey, Joe.
Hey, guys. Thanks for attending today.
Thanks for voluntarily, compulsorily agreeing to do this.
Voluntary compulsory doing this.
I make it hard for you to say no to me. All right, so our agenda for today, we've taken a very practical approach. So we'll be focusing on what the reforms mean and what you need to do in order to implement those changes. I'll only be speaking briefly of the actual legislation as it's a bit of a minefield. And really it's our job to worry about the technical aspects of it. So if you do want more specific information, please reach out to us and we'll be happy to help. But since there's so much to cover today, we'll just be looking at a few key focus areas. And then you consider how they apply to you, and then we can give you some tailored advice. But hopefully we cover a lot of ground, which will be relevant to you and your business. So why are we here today? So you would have heard in the media a lot of hype about all of the workplace reforms, which have been labelled as the biggest since Fair Work commenced. And you'll see here listed on this screen that there are 3 new key acts which have come into force in 2022, and they're listed there. So the first that we have is the Paid Family and Domestic Violence Leave Act, which came into force in November last year. And it's pretty self-explanatory in the title. It provides for paid family and domestic violence leave. And I'll talk a little bit more about the specifics later on and how you actually can apply it in the workplace. The next one is a really big one that was probably the subject of most of the media hype. And this is the Secure Jobs Better Pay Act. A huge hint about what it does is in the description on the front page, which you can see here, I'm hovering over. And at the start it reads, an act to abolish the Registered Organisations Commission and the Australian Building and Construction Commission. So it's pretty clear, it tells you what it does there and pretty much that our job's done now. The second half though is not as clear, and that is to amend the laws relating to workplace relations and workers' comp and rehabilitation and for related reasons. So really that second half is what we'll be talking about in a lot of detail today. So as you can see, it amends 3 different acts, with the main one being the Fair Work Act. And all of those changes are being rolled out over the next 12 months from when it commenced. So really in 2023. And we've submitted a timeline for this act at the end of our presentation. So you get a very good visual understanding of the relevant dates and what you need to know. So the last act you need to know is the Respect at Work Act. And this one covers quite a few different legislations, and its aim is to address sexual harassment and discrimination in the workplace. Now, this act, for the first time ever, creates a positive duty to eliminate sexual harassment and discrimination in the workplace. So it is really important that you know this one. So towards the end of the presentation, we have a very clear and precise checklist that covers what you need to do to address all of these changes. So don't be overwhelmed. Try not to be overwhelmed with the enormity of the changes coming to effect. We've kind of broken it down with a very clear to-do list of what you can do to make sure you're compliant. So as I said earlier, we're not going to get too technical. And by that, I mean, we're not going to be sprouting specific sections and reading out chunky paragraphs of legal nonsense. Instead, we've broken down categories of changes and that are observed across each of those 3 acts. And you can see here that there's quite a few, however, and that's not surprising because it is quite significant reforms. As I said earlier, the biggest since Fair Work came into effect. But this is a quick snapshot of what the reforms actually are, and you can read them here. That it affects lots of different areas, but there is some correlation between them. So, getting into the nitty gritty and what they actually mean, I'm going to hand over to Joey, who's going to be talking first about pay equality.
Thanks, Sarah. Okay, so the Secure Jobs Better Pay Act was one of the acts that came into effect in December last year. It introduced a number of reforms aimed at promoting wage growth, job security, as well as modernising and ensuring a fairer workplace relation system for employees, such as with regards to job security and gender equality. So I will start to go through some of those reforms now. Like Sarah said, there are a lot. And it's impossible to cover all of these in the hour that we've got today, but we will sort of give some advice and some information about some of those changes. One of those reforms was the banning of pay secrecy clauses in employment contracts. Now, generally, employment contracts commonly contain provisions requiring an employee to keep their remuneration strictly confidential, and breaching these confidentiality clauses in relation to your remuneration in employment contracts in the past has given an employer the ability and a valid and lawful reason to institute sort of disciplinary action against the relevant employee, including leading to their termination if they've breached and disclosed their remuneration in the past. Now, the pay secrecy reforms are intended to promote pay transparency by basically prohibiting any pay secrecy clauses. So what this means is that employees now have a workplace right to disclose or not disclose. It's up to the relevant employee. If they don't want to disclose their pay, then they don't need to. But employees have a workplace right to disclose, as well as asking other employees any information regarding their remuneration or terms and conditions attached to their employment that are reasonably necessary to determine their remuneration, such as the hours of work that an employee does. So, what this means is there's nothing stopping an employee from talking to other employees about, their remuneration. Now, another employee may not wish to disclose this, so you can't compel them to, but there is nothing stopping from 2 employees engaging in conversation to discuss their respective remuneration. By making it a workplace right to discuss remuneration, it means that an employer now is unable to take any adverse action or steps against an employee for any such disclosures. And it gives the employee an ability to pursue a claim against their employer if they are, for example, disciplined or terminated from their employment because they disclosed their remuneration or discussed it with somebody else. It's important to note that the pay secrecy reforms have already come into effect and apply to employment contracts that have been entered into from 7 December 2022. For any employment contracts entered into prior 7 December 2022, it means that any pay secrecy clauses in those contracts no longer take effect. So they're redundant. It's like they don't exist, even if they're in an employment contract prior to 7 December 2022. And also any variation of existing employees, so if you vary their employment contracts or any new employment contracts, are not to have any clauses with respect to pay secrecy. There is a 6-month grace period to allow employees to get up to speed with things and make sure everything is right from a document point of view with their employment agreements. So from 7 June 2023, employers who enter into employment agreements that include pay secrecy provisions can be held liable and exposed to penalties of up to $66,600 per contravention for a corporate company. It's therefore important for employers to consider their existing employment agreements, as well as new or potentially revised employment agreements in the future, so that they can ensure that they're on board with the pay secrecy provisions and don't have any pay secrecy clauses in those contracts. Okay, so another reform has been the establishment of 2 new expert panels in the Fair Work Commission, one for pay equity and another one for the care and community sector. Now, the intent of these 2 expert panels is to basically hear wage-related matters and help address low wages and challenging workplace conditions faced in the care and community sector. So these reforms have been implemented to ensure pay equity claims and relevant award variation applications are considered by the Commission with members that have the knowledge and experience in these areas. Another reform of the Secure Jobs, Better Pay Act has introduced restrictions in relation to job advertisements and the imposition of penalties to employers who advertise jobs with pay rates that don't comply with the minimum employment conditions or terms under the Fair Work legislation, or any relevant modern awards or enterprise agreements that apply to your business. This reform has already come into effect, so it's important to know of the change and make sure that you're taking all the right steps to avoid potentially engaging in any sort of or posting any sort of job advertisements that are prohibited. So, for example, if an employer seeks to put a rate of pay in a job advertisement, the rate cannot be below the minimum wage, and there is a minimum rate and a minimum wage that the Fair Work Act sets, or it also can't be below any other applicable minimum rate of pay. So, if an employee falls under a relevant award or enterprise agreement, so the advertisement can't be putting a rate of pay that is below the minimum applicable as by law. So the purpose of these changes are to do a couple of things. First, they are to encourage employers to consider their workplace obligations before advertising for a job. It's also to promote a culture that prioritises awareness and compliance with the relevant legislation and the laws. And it's also to reduce worker exploitation and unintentional underpayments of employees. And for those that may know, there have been a lot of underpayment claims and underpayment issues in all organisations, and this is really one of the ways they're trying to sort of target underpayment claims and make sure that workers aren't being exploited and paying at least the minimum rate that they're required to be paid by law. So the prohibition on non-compliant job advertisements took effect from 7 December 2022 and therefore requires immediate action by employers which will now require them to at least be aware of employee minimum rates of pay under any relevant legislation, modern awards, enterprise agreements, as well as any other additional entitlements that may affect these pay rates, to ensure when they are now and in the future advertising for jobs, they are advertising for jobs, and if they're disclosing the rate of pay, it's the rate of pay, the minimum rate of pay allowed by law. Another reform established by legislation is in relation to the procedures under the Small Claims Division. And what this, so the Small Claims Division ultimately is a process where employees are able to recover unpaid entitlements in a cost-effective manner. So prior to the changes, it had a monetary cap of $20,000. But in light of these reforms, the monetary cap has now been increased from $20,000 to $100,000. The increase in the cap is basically intended to allow more prospective claimants with modest claims to benefit from a simpler, quicker, and cheaper approach to dispute resolution, and to avoid prospective claimants who would have had a modest claim that exceeded $20,000 from abandoning part or the entire of their claim to now bring it within the monetary cap. and essentially pursuing any underpayment or other entitlements that would fall within the small claims division. As part of the reform also, in addition to the small claims division, employees can now also elect to commence their own legal action against their employer to seek to recover underpayments in respect of certain disputes regarding casual conversion requests, for example, in the Federal Circuit Court and Family Court or any relevant state court. So in such proceedings, the court is not bound by the rules of evidence, and they can act in an informed manner. So it's basically to reduce the technicalities, to make it a more streamlined, efficient, quicker process, to allow claimants, those that are alleging underpayment claims, to essentially seek a remedy or compensation or the like in a much more streamlined, informal, less technical, quicker process. So the small claims division reforms are scheduled to come into effect from 1 July 2023. Over to you, Sarah.
Thanks, Joe. So the second focus we have as part of the changes is on the increased protections and entitlements, which are respect and family based, really. And they come into play because they deal with protections against sexual harassment and additional protections around requests for parental leave and flexible working arrangements. And there was also the introduction, as I mentioned earlier, of the paid family and domestic violence leave. So first, looking at sexual harassment, where some of the most groundbreaking and landmark provisions have been introduced through the Respect at Work Act, which amends the legislation which I listed above. But really, the most important thing to take away from this slide is that it actually creates a positive duty on employers to eliminate sexual harassment by taking measures which must be reasonable and proportionate. So this positive duty, as I said earlier, is it's a new obligation imposed on employers. And what does it mean in practice? What it means is that you really can't sit back and just address sexual harassment if and when it enters the workplace. Instead, employers need to take preventative action to stop it from happening. So this means conducting a review of the organisation and identifying risk factors and taking steps to reduce those risks. So there's some really obvious actions that you can take are implementing strong and clear policies on discrimination and harassment, communicating them and making sure they're properly applied, providing relevant and practical training for all staff to ensure that they understand the rules and to include in those rules some obligations on bystanders to ensure that everybody is taking that preventative action. So it's not just the case that it should be managers taking this training, it's all staff. So it's also essential to provide a safe space for those bystanders to take action and to communicate a clear complaint process and then taking appropriate action if and when a complaint is made. So once a complaint is made, an investigation occurs and then a determination made, it's necessary then to take the proportionate action when needed. So keeping in mind, though, that this positive duty applies to not only sexual harassment, which for those of you who don't know, is the definition is unwelcome conduct of a sexual nature, but these rules also apply to harassments on the grounds of sex, which is really unwelcome conduct based on the sex of a person, which is not necessarily sexual in nature. And there's also discrimination based on the grounds of sex. So it covers all of that broad aspects. The positive duty goes so far to require the employers to eliminate the conduct that subjects a person to a hostile environment. And again, this doesn't just mean being reactive, but being actually proactive. So by these new changes, we have the Australian Human Rights Commission, who's been granted expanded powers that will kick into gear 12 months after the Respect at Work Act comes into force. So this allows businesses to get up to speed with their new positive duty. So there's a bit of a grace period, but after that 12-month period, then there's not really going to be any excuses. Employers need to make sure that they're doing the right thing. So those powers of the Commission will allow them to conduct their own inquiries, to provide recommendations, and to give compliance notices, and also to apply to the Federal Court to enforce those notices. So it even goes further with the Secure Jobs and Secure Pay Act. So what I talked about previously was the Respect at Work Act. This is the Secure Jobs, Secure Pay Act, where it actually expressly makes unlawful, sexual harassment becomes unlawful conduct. So this then allows preventative action. This then allows just disciplinary action to occur if there's any suggestion of sexual harassment in the workplace. And the unlawfulness has an expanded scope as well to include not just employees, but all other range of workers such as contractors, subcontractors, students, volunteers, interns, and even prospective workers. So it has a very broad application. The Act has provided additional avenues also for workers to pursue if they are the victims of sexual harassment. And this includes things like the Stop Bullying orders. There's now a Stop Sexual Harassment order that a worker can seek through the Fair Work Commission. I would hope, though, by the time it gets to that stage, that the workplace is taking steps to stop the sexual harassment from occurring. So in that sense, I hope that avenue becomes obsolete, but nonetheless, it's there and it's an avenue that workers can pursue if they need it. Any breaches, though, may result in claims or civil penalties. So it's really important that businesses take these proactive steps to make sure that they're compliant. Also, and just to have a nice work culture as well, really, there shouldn't be these laws, but they are for protections, but, it gives a bit of a framework of what you should be doing. So now looking at the family and domestic violence leave. So before this Act came into place, employees were entitled to 5 days of unpaid leave. Now with this Act, they can access up to 10 leave days per year, which kicks in instantly from the date that they're employed, unless you're a small business with less than 15 employees, and therefore that doesn't start until the 1st of August 2023. So it's just allowing small businesses some time to get up to speed with this stuff. So the leave doesn't accumulate each year. So if it's not used, it doesn't go to 20 days the next year or 30 days the year after that. It's always 10 days. Although if the employee does use the 10 days in a year period, then they get another 10 days in the second period. So it can be accessed by anyone experiencing domestic violence, and it might be used for things such as making arrangements for their safety, attending court hearings, going to the police station, counselling, or appointments such as legal, medical, or financial appointments. And the domestic and family violence can include both coercive control as well as violence, threatening, or abusive behaviour. And it doesn't just have to be from somebody's partner or spouse. It can be a list of people including anyone in their household. So the rate of pay that you need to apply if somebody wishes to access this leave is the full amount of their pay for the amount of hours that they would have worked if not on leave. And it actually applies also to casual workers who were rostered on. So this could also include bonuses, loading, allowances, overtime, and penalties. So it is treated a little bit differently than annual leave, although there are strict rules about what you can put on the pay slips. And this is for safety reasons. So you can't note it as domestic or family violence leave on the pay slip. You can note it as ordinary pay or annual leave if that's what's been agreed, but you have to be very careful about that. Which does create some difficulties, but I'm not across payroll systems, but you should have a look to see if your payroll system or provider actually does make provisions for this to make sure that you can be compliant if somebody is needing to access it. I'm expecting I'm going to have a lot of questions about how this can be evidenced and also notice periods. So what I mean by evidenced is if somebody's taking personal leave, for example, if they're sick, ordinarily the policy is that they have to provide a medical certificate. In this instance, the employee might not have a medical certificate. In fact, most instances they don't. So the employer is entitled to ask for some support, some evidence to support the leave request, but they have to be careful about what they ultimately do with that information that they get. So they can't use it for any other reason other than to support the leave request. And also with the notice period, the employee does not have to give advance notice like they would for annual leave, for example. They do have to give notice as quickly as possible, but it might be that after they actually need to access that leave. So there's some mechanisms in here to kind of address the actual underlying issues and how domestic violence operates. Now, we actually work with some fantastic organisations as part of our pro bono initiatives. One's the Northern Centre and one is the Centre Care in Griffith, who deal with a lot of domestic violence and provide support and resources. So if you do want some further guidance and strategies to put in place to create a safe environment for workers, reach out, we can get you in touch with those wonderful organisations. But from a legal perspective, I recommend that businesses do implement a policy or update their leave policies, if not already, to make sure that this is covered. So now looking upon the additional protections, these come into play with the unpaid parental leave and the flexible working arrangement requests. So the Act really builds upon this process that already was in existence. So firstly, it expands upon the circumstances in which requests can be made, and that includes situations where the employee is experiencing family and domestic violence. So as most of you might know, there are rules around the formal flexible working arrangement requests. And we've spoken about these in other presentations. If you want a refresher, just get in touch. But for today, we will just be talking about the additional rules that have come into force with the introduction of the new acts. So the new obligation really is that you have to meet with an employee once they make the request to discuss the request. And you have to kind of go through and workshop ways in which you can accommodate the request. If you can't accommodate the request, then you need to set out in writing the reasons for the refusal, and they have to be based on reasonable business grounds. So it can't just be because I want you in the office. It has to be more than that. So we often get requests from clients or instructions from clients to go through this process with them. And then it's just a matter of making sure we go through and covering all bases to see whether you actually can accommodate it in the first instance. And if so, why not set that out in a very clear way? If you don't, then there's new mechanisms that the Act's introduced that says what will happen if you don't comply with your obligations to meet, and then also to provide a response. And that first step is through a dispute resolution mechanism, and that is conciliation. And then if appropriate, then the employee can actually make an application to the Fair Work Commission and seek an order. So this is an instance where obligations are imposed on the employer, which have consequences, real consequences, if not complied with. And therefore you need to make sure that you've got steps that you can take once a request is made, and that everyone is given proper training. This includes managers and any HR or employees, just to understand what they can and can't do. So these come into effect from 6 June 2023, and the same applies for the unpaid parental leave. So there's time for you to get your policies up to date and to understand what this means, but make sure you're ready to go by June 6th. So I'll be handing back over to Joey, who's going to be talking about some of the structural changes in some of the contracts.
Thanks, Sarah. Okay, so more reforms. So the Secure Jobs Better Pay Act has introduced significant further reforms in relation to the use of fixed term and maximum term contracts, enterprise agreements, enterprise bargaining, as well as the abolishment of the Registered Organisation Commission and the Australian Building Construction Commission. Like I've said before, and as Sarah has said, there are a lot of changes. So I will just briefly be discussing a few of these, although if you have any further questions, feel free to ask or reach out to us separately. Okay, so the fixed term and maximum term contracts. In relation to these sort of contracts, significant reforms have been introduced that will now limit their use. So while these types of contracts were initially designed to give employers some flexibility in the workforce, given that there was an end date in which they engaged an employee, what happened in many instances was that these contracts would be regularly renewed or extended at the end of each end term on a rolling basis, which ultimately created a bit of a de facto permanent employment for the employee, but limited the benefits and the rights that the employee would ordinarily receive if they were a permanent employee, not a fixed term employee. So this created job uncertainty for employees that were on these sort of fixed term or maximum term contracts. So the reforms are designed to increase, so these reforms regarding fixed term and maximum term contracts are designed to increase job certainty and permanent employment by basically compelling employers to offer genuine fixed term arrangements or otherwise permanent employment to these employees. So it is also just important to note that the reforms don't apply to casual workers. There are separate rules for casual workers and casual conversions and things like that, which we've discussed in previous webinars. And as Sarah has said, if you need information about casual workers and casual conversion, feel free to reach out to us so we can discuss that separately. But in relation to fixed term and maximum term contracts, they're only in relation to part-time and full-time employees. Once the reforms come into effect in relation to these contracts, employers will be prohibited from engaging an employee on these fixed term contracts on the following basis. So a contract that is more than 2 years, or such contracts that that these contracts that exceed 2 years together, secondly, a contract that allows for renewal so that the employee will be employed for more than 2 years, or consecutive contracts of employment where the employee is performing the same or substantially similar work under consecutive contracts. So, of course, you know, when a law is made, there are also equally the amount of exemptions that sometimes apply to restrictions. And in these circumstances, there are some exemptions that would apply that would allow for more than, for example, 2-year fixed-term contracts. And some of those include where the work is for a distinct and identifiable task involving some sort of specialized skills or training arrangements, or for essential work during a peak demand period, or for work during emergency circumstances, or during a temporary absence of another employee. It also includes situations where the employee earns above the high income threshold during the relevant year they enter into the contract. It includes governance positions that have a time limit under governing rules, or alternatively where a modern award allows for it. So similar to the employees and casuals where you've got information statements, employers will now also be required to provide employees on a fixed term contract with a fixed term contract information statement before or as soon as practical as after the contract is entered into. So what this means is that any contract clause that does not comply with the proposed limitations that I've just discussed will be unlawful and will have no effect from 6 December 2023. And employers, if they do engage in such activity, will be exposed to penalties. So what this means for an employer is that now is an opportune time to review the makeup of the employees in your workforce, especially those that are on fixed term contracts, as well as the terms of those contracts, you know, to get up to speed, to prepare and to ensure compliance in anticipation of when the changes are to come into effect later this year. I'll just touch upon a bit of enterprise bargaining and bargaining agreements now. Okay, so as I've said, the reforms have also introduced significant reforms to the enterprise bargaining framework by reducing barriers to multi-enterprise bargaining and expanding the Fair Work Commission's powers to resolve bargaining disputes up to and including arbitration. So in relation to enterprise bargaining, the multi-employer bargaining reforms means that there are now reduced barriers to access the existing multi-employer bargaining streams. It does get quite technical, so I'm not going to discuss the various ins and outs of these streams here, but if you do want further advice on this, please feel free to reach out to us and we'll be happy to discuss separately. In relation to the bargaining process, the reforms have also introduced reduced barriers to commence bargaining for the replacement of enterprise agreements. So when the nominal period expires for one, there are reduced barriers now for further enterprise bargaining agreements. And what this means is that employers who have previously bargained with employees will have fewer options to resist bargaining for new enterprise agreements. The reforms also remove the need, again, in relation to replacement enterprise agreements, the reforms remove the need for a notice of employee representational rights to be issued to commence bargaining for a replacement enterprise agreement. Now, as such, bargaining will commence on written request from an employee bargaining representative, and this is a much simpler process, and it's a less procedural approach to commence bargaining. It also removes opportunities for employers to resist bargaining. So what does this mean? The various enterprise bargaining reforms overall are likely to apply more pressure on employers to bargain, and it is a less restrictive and a less procedural process for bargaining agreements to get kicked off through the bargaining process and for bargaining agreements to be approved. So that's that. Now, a separate part of the reforms and a big one is zombie agreements. So what is a zombie agreement, you might ask? A zombie agreement is a term used to describe enterprise agreements that have passed their nominal expiry date but remain preserved in law, which means they're not illegal. So the problem with these zombie agreements is that because they're so old, they may contain terms and conditions which are less favorable to employees than those employees which would be entitled to a new enterprise agreement currently or under a modern award. So under these reforms, all zombie agreements will automatically terminate on 7 December 2023, unless the Fair Work Commission approves an extension to any of these zombie agreements by request of the parties. So after 7 December 2023, if a replacement current zombie agreement has not been entered into or extended, then the relevant modern award will apply to the employer and the employees previously that would have been covered by a zombie agreement. So does a zombie agreement apply to your business? Well, the Fair Work website has published a very, very long list of enterprise agreements that they have identified that will automatically terminate on 7 December 2023 unless there is an application for extension that is approved by the Fair Work Commission. So if you are unsure whether, if you're operating under a so-called zombie agreement and you're unsure whether this is going to terminate after 7 December 2023, feel free to reach out to us so we can provide you some more information and guidance on this. So what does this mean for employers in relation to zombie agreements? Well, employers that are covered by zombie agreements must now start to consider what these changes mean for their operations and what appropriate steps should be taken, whether that is to have their employees revert back to the relevant modern award or to seek to extend the zombie agreement with the approval of the Fair Work Commission, or alternatively to seek to enter into a new enterprise agreement and kickstart the bargaining process for this new enterprise bargaining agreement. There are various things that need to be considered here depending on what approach an employer wants to take. So if this is something that is relevant to your business and you require some further advice or assistance with it, as always, feel free to reach out to us so we can assist further. Now, in relation to enterprise agreements, generally, the Secure Jobs Better Pay Act has introduced reform mainly in relation to procedural aspects of the process for an enterprise agreement to be approved by the Fair Work Commission, as well as unilateral termination of an enterprise agreement, and the Better Off Overall test, or what we, employment lawyers commonly refer to as BOOT, B-O-O-T. So in relation to the procedural requirements, currently there's onerous pre-approval requirements for enterprise agreements that are replaced by more broader requirements that the Fair Work Commission be satisfied that the employees genuinely agreed to the enterprise agreement. So less procedural steps and requirements here in relation to pre-approval requirements for an enterprise agreement. Also, in relation to the termination of any enterprise agreement, previously the Fair Work Commission needed only to be satisfied that the termination of an enterprise agreement which passed its nominal expiry date was not contrary to the public interest, and it took into account the views of the parties to the enterprise agreement. So what the reforms now require the Fair Work Commission to do instead is to be satisfied of one of the following, which I'll point out prior to terminating any existing enterprise agreement. And they include: one, whether the continued operation of the enterprise agreement would be unfair to the employees it covers. Two, whether the enterprise agreement does not and is not likely to cover any employees. Or three, whether the continued operation of the enterprise agreement would pose a significant risk to the viability of the business, and terminating the enterprise agreement would reduce the risk of terminations of employees under that business, and the employer gives a guarantee that it will preserve termination entitlements under the agreement. So the new reforms in relation to the enterprise bargaining agreement process, as I've sort of just touched upon, makes it more difficult for employers to terminate out-of-date agreements. And these reforms, it's important to note that these reforms have already come into effect from 7 December 2022. And as such, if you are an employer that has an enterprise agreement and are considering terminating it or want specific advice in relation to the enterprise bargaining agreement, you should consider your strategy now. Again, as always, feel free to reach out to us if you have any questions about that. And I'll just touch upon the boot test that's been reformed by the changes. So the Secure Jobs Better Pay Act introduced reforms to the Better Off Overall test to address some of the concerns that have been raised in the past as to its application. So in particular, the reforms require the Fair Work Commission to undertake the Better Off Overall test as a global assessment instead of a line-by-line comparison. So what this means is that the Fair Work Commission only needs to apply boot to reasonably foreseeable patterns or types of work under the enterprise agreement, which reduces sort of the risk of hypothetical scenarios under any sort of relevant enterprise agreement that in the past had the potential to bring down the entire enterprise agreement. Now, another significant reform is that the Fair Work Commission is also now able to amend proposed enterprise agreements itself to either amend or remove terms which don't meet the Better Off Overall test. So this means that the proposed enterprise agreement won't need to be voted on again by employees, and that sort of long drawn out process is now avoided, and it's a more streamlined process in relation to any amendments or removal of terms in an existing enterprise agreement. So the reforms to the Better Off Overall test with respect to enterprise agreements is due to come into effect 6 June 2023. In addition to implementation or removal of some existing sort of rules or laws, the Secure Jobs Better Pay Act has also abolished both the Australian Building and Construction Commission as well as the Registered Organisation Commission. And from 1 July 2023, it has established the National Construction Industry Forum. So just briefly explain the two commissions that are being abolished. The Australian Building and Construction Commission primarily dealt with workplace relations, investigations, and breaches in the building and construction industry. However, now that it's been abolished, the Fair Work Ombudsman is now going to be the workplace relations regulator responsible for the construction industry. And in relation to the Registered Organisation Commission, this was a body that was initially established to ensure better governance and financial transparency of registered organisations and employer associations. However, it has now been abolished, and its powers and regulatory functions will be absorbed by the Fair Work Commission. Thanks, Sarah. Now it's over to you.
Thanks, Joe. So I'm sure you're all thinking that's quite a lot of information. It's kind of different fields. You're talking about enterprise bargaining, and you're talking about sexual harassment, and so it covers a really broad spectrum of different areas. So what we've got here, and this is from the Fair Work Commission, so we've essentially just cut and paste, and you can go onto the Fair Work Commission website and get more information about this. But this is a really good visual snapshot of what you can, what you need to do and what you need to know from this Secure Jobs Better Pay Act. Some of the important dates that you need to remember is the 6th of June, where the flexible working requests need to be adhered to with the new rules, and that means meeting with them and then responding in writing. There's also the date of 6 December, which then means that any fixed term contracts become invalid if they're over a 2-year period. So if you are a business that's also needs to engage in bargaining and enterprise agreements, then you need to consider a strategy, so that you'll need advice about that. So get in touch with us when you talk more about the specifics. But it's really important that you know the dates for this. Another date is 6th of March, where there's the prohibiting of sexual harassment in connection with work, and this makes it unlawful, and that's why you need to be doing these things. It's already passed, so we're now into March, so there's no excuse about businesses that don't take the right steps to get this sorted out. So now we've overwhelmed you with that information. We've actually created a bit of a checklist that helps you to kind of go through point by point to see the kind of things that you need to do to make sure that you comply. So it's not overly complicated. There's 8 simple steps. In true lawyer fashion, we have been slightly vague in where we say create and implement policies. And this is because every business is different. So you're obviously going to have a different kind of policy. If you're, a small business with a couple of people, you're not going to create too much rules and procedures for a couple of people, but you still absolutely can have a policy, even if it's something as simple as, respect one another, no specific jokes or no kind of conduct that's going to make someone uncomfortable. You can have that policy, that's no problem. It doesn't matter about the size. It's about how kind of onerous and the procedures that you take in terms of the size of your organisation that you set out. So the first one obviously is the reviewing the employment agreements to update pay secrecy clauses. We did have a very good question that was put in the chat. That was, do you need to do new agreements to remove the pay secrecy clauses? No, you don't need to change all of the existing agreements, but you absolutely need to update the agreements for any new employees that start or any variations to employment contracts. And when we say variation, this includes, for example, if you give a pay rise or a promotion, you need to make sure that those pay secrecy clauses are removed. So you don't need to go through and change everything, but moving forward, everything needs to be properly set out. So then we've also listed a bunch of suggestions about the policies that you can implement. As I mentioned earlier, the family and domestic violence leave, it's really important that you should have an annual leave or a personal leave policy in place as well. Just update it to make sure it includes that, and inform your payroll and HR about the process in that respect. You can create some kind of procedures about how you can access that, or how employees can access it, and how it's then going to be dealt with on your pay slips to make sure everybody's aware of what's going on. And then obviously we're dealing with the biggest changes, as I talked earlier, was around the sexual harassment and discrimination. And that's where you have to take proactive steps to do it. So having policies, having procedures, doing training, making sure you're creating a safe space. This is really important work that needs to be done. There's a reason that this has occurred, and this is to address some of the systemic problems that are occurring in workplaces. And so there's going to be, in my view, a bit of a crackdown and focus on these to make sure the business is doing everything they can. Again, it needs to be proportionate to the size of your business and what you have going on. It's not expected if you're a small business that you're going to have to spend significant money addressing these things. There's things you can do without spending the money. There's trainings you can do. For example, joining this webinar is one. So well done, you're already halfway there. But there's information you can get and great policies and procedures that we can help you out with that are cost effective, but it allows you some guidelines of what you can do. And then speaking of training, come to us. We can do further one-on-one training. So what we have is an educational program, which is focused on employment law, which we really just customise training and any seminars for your business. So Joey and I have been doing this for quite a few years, where we go into a business and we conduct customised training for our clients. And this covers a number of different employment-related topics, always employment-related, but really depends upon the issues the business are having. So Joey's done quite a few of these as well. And so what are some of the topics that you help clients with, Joe?
Yeah, so look, the various training sessions that I provide, as you said, they're customized to the business. So what one business might have or want to address, their managers and their staff are different to another. So it is a varied range of topics, but they include things like topics such as bullying and harassment, procedural fairness, a general overview of the termination process, including unfair dismissals and general protections claims. As you've touched upon, sexual harassment and discrimination is a big one. Work health and safety and compliance, as well as performance plans and disciplinary management. So there's a whole mixed sort of bag of topics that we, provide training sessions for many of our clients. And like I said, it just really depends on their specific circumstances, any sort of issues they're facing in their workplace, and information that they want to provide to, their managers and their staff, to provide them with information, training sessions, to, make sure they're doing the right thing. Now, the feedback we get from these sessions are very, very positive from, staff and managers that do attend. These training sessions we find are best done in person. So we usually go to our clients' offices, in their boardroom or whatever, and we.
Or you've also gone out to a factory, I remember.
Yeah, factory. That was an interesting one.
With your hard hat and your high vis.
I got a tour through the factory and to see, where all the real stuff was done. But otherwise, look, if you don't have the space or can't run the sort of session at your premises, you can come to our office, and we can do it here. We've got room, we've got boardroom, we've got plenty of space, so that's something else we can do. We do find our sessions, especially because they're in person, they're very interactive. You can ask questions throughout, and people are very engaged, and they find it very beneficial in these training sessions that we provide.
Yeah. Oh, but you can also do the Zoom sessions. I know you did one recently where the employee has 3,000 employees, and then one into groups of 50s to allow people to ask questions. So that's absolutely possible.
Yeah. So I spent a couple of days for that one, where they have got about 3,000 or so. So they provided the option over a couple of days, and then they all just jumped on the Zoom, and I gave a couple of training sessions to these staff in relation to topics that they wanted addressed.
Yeah, so we'll get to questions in a sec, but jump on that QR code if you want to get more information about the training session. So I've got a couple of questions coming through that we'll answer live. Just note this is a recording, so if you do need to jump off now because of time, then we'll send through the recording, which will include all the questions. Otherwise, here are our contact details. Call us, email us. We love having a chat, so get in touch with us if you need. Also, before we get to the questions, I just wanted to plug our upcoming event. We have a fantastic new head of IP, who's Tyrone Walker. You see his nice picture there, who joins us as an expert in this area, and he'll be talking about the value of IP and trademarks. Now, IP and trademarks is something, not trademarks, IP is something you should include in your employment agreements anyway to make sure you're protecting any of your intellectual property. So he'll be talking about that as well from an employment aspect. But now on to the all-important questions. So we've got quite a few that's come through. We might start with an easy one, but the question is, are you able to expand on the extension of unpaid parental leave changes occurring as of 6 June? Yes, that is that you have to follow the same process as you do for flexible working arrangements when a request is made, and that is to meet with the person and to talk about reasons why the request can or can't be accommodated. If it can't be accommodated, you need to put it in writing. So that unpaid parental leave request, so employees who take parental leave are entitled to 12 months of unpaid leave, and then they're ultimately entitled to another 12-month period. So this is if any extensions to that, if the business can't afford to, for example, keep extending the unpaid parental leave, then it's about going through the process to make sure that that's it's properly followed. So the same things that you can apply to your flexible working arrangements requests, you can apply to your unpaid parental leave. Another question we have is, what defines creating a safe space? it's a little ambiguous, but what I guess what I was talking about when I mentioned that would be creating a space where people feel as though they're able to put forward complaints in a safe manner, that they're not going to be, that the complaints will be addressed, that they're not going to be subject themselves to scrutiny by putting the complaint, whether it be they're the ones who are the victim of the sexual harassment and discrimination, or they're a bystander. So it's about essentially not shooting the messenger in that case. But that safe space means having a really clear and empathetic procedure, and also a discrete procedure that allows these complaints to be dealt with properly, and also making it fair, because you want to make sure that there's an opportunity for all of the parties involved in the complaint to put forward their position. Particularly with sexual harassment, it is something that is quite a difficult area because it is very subjective in that it's based upon unwelcome conduct. So what might be unwelcome for one person is not unwelcome for another. And this is where it becomes quite difficult. But a lot of the time it's common sense. And if it's something, and I'm talking about kind of the lower level of severity, if it's a comment that, is a bit borderline, but it makes someone feel unwelcome, absolutely you need to address that. But the response to that complaint is very different than somebody who's actually been engaged in physical sexual harassment. In the case of the comments, which are still damaging, but if it's something that was unintended and the person just needed more training on, then that's the appropriate response of giving them perhaps a warning, giving them the training, making sure it's clear what is and isn't acceptable. For leaders, it is leading by example. So it's not a case of do as I say, not as I do. It's about showing and demonstrating to the team what is appropriate conduct. And so that's what I mean by creating that safe space, giving them an opportunity to put forward complaints and not feel persecuted by doing that. Joey, anything else to add to that one that you can think of?
I think you've covered it quite comprehensively, to be honest. I think in relation to Kate, I think one further question regarding agreements with the contractors regarding pay secrecy. The legislation does not cover pay secrecy in relation to independent contractors. That's the short answer to that.
Then I've got a question from Carol, which is not quite on the topic we're talking about, but we can still answer it. That is, if a staff member is now working from home permanently, is workers' comp still required to be paid by the employer? Absolutely, yes. The answer is to that. And does a self-employed tradie without staff need to pay workers' comp? Carol, we'll be in touch with you because it's not quite what we're talking about in this session. So just if we can remain on topic for these ones. So we've got, what about objects of sexual nature displayed on desks in the workplace? Yeah, that's a really good question, actually. Yeah, absolutely. They should be removed from the workplace. It would be I can't envisage an instance, unless you're in the medical profession where it's needed for educational purposes or training purposes, where you'd have objects of a sexual nature displayed on a desk. If you're talking about a fairly typical office environment, such as a law firm, for example, I cannot envisage any situation where it would be appropriate to have objects of a sexual nature displayed on a desk in a workplace. And I can't think of any justification that an employee might say to have it there. It should be removed because it has the potential to create that hostile environment. It might indicate that the workplace allows that kind of environment, that promotes that kind of environment, and it would be unwelcome, particularly because if somebody has to be in that space, which they probably do for workplace, they're being forced to be engaged in that environment. So I think as you touched upon, it creates positive obligations for employers to take steps. So if for example, an employer is aware of these things and they've got the positive obligation to take steps to reduce these sorts of sexual harassment or things like that in the workplace, which has been clear in the legislation that's been enacted. Yeah. So the next question, which is also another good one, what if an employee continues to ask another employee out on a date? That again is quite tricky, because I remember hearing stats that a number of relationships, genuine relationships, marriages, for example, born from workplace environments. So a lot of people do end up together based upon those workplace relationships. And that's completely fine if you have two consenting adults who want to engage in a workplace. However, if you do have an unwanted situation where there's essentially unrequited love, in my view, the first request for a date would probably not, if it's done in a respectful manner, if it's done not in a confrontational way, it could still fall under the definition of sexual harassment if it is unwelcome conduct of a sexual nature. However, if it's not kind of done in an inappropriate manner and it's just an invitation out for a date, and the person says, no, I don't see a problem with that myself. However, if it's ongoing and repeated, then absolutely you would fall into that category. I have had experience in dealing with those kind of complaints for clients, and the response to that was just having a conversation with the person, the initiator really, who was continually asking the person out on dates and just demonstrating that it's inappropriate, that they've provided a response, they're feeling uncomfortable, and bringing it to their attention. What happens in almost every single case is that person feels quite embarrassed and uncomfortable. So you need to do it in a discreet way. You're not there to try and embarrass somebody, but they often aren't realizing what they're doing and how inappropriate it is. And by pointing it out, in almost every case, it stops. If it doesn't stop, then disciplinary action should be taken. So the person might file a complaint. You need to make sure that all of your employees are in a safe working environment. And so obviously you might be embarking upon a territory where the person who's being asked out is feeling uncomfortable, and that might create potentially an unsafe environment for them, which is contrary to the work health and safety rules. So it needs to be addressed, but address it in a proportionate manner in which the actions are being taken. We've got another question. So is there a positive obligation on employees to notify the employee that sexual harassment has occurred within the workplace? I'm not aware of that, to notify that sexual harassment has occurred. If it subjects everybody to potentially sexual harassment, for example, it might, and it can be approached in terms of giving additional training, but on balance, I would suggest that no, you would not be telling others about inappropriate conduct if it's being dealt with accordingly. If the risk has been removed, then there's no reason I think that everybody should know, particularly if it's something that's not yet been established. For example, if a complaint has been made, take steps to eliminate that risk, and that might be directing somebody to work from home, or suspending them with pay, or suspending them without pay, depending upon the severity of it, while the investigation is being conducted. And then I can't see a need, if that risk has been eliminated, to inform other employees. But it might be a good opportunity to then engage in further training for all the staff to make sure that they know what is and isn't appropriate, or reminding people of policies, or just consulting with them, providing some counselling if needed, if they've witnessed it. But it would really depend upon what level of involvement they had in it. Joe, anything else to add for that one?
No, I just think if you're an employee and you've had sexual harassment or witnessed sexual harassment in the workplace, and you're more than welcome to put forward a grievance, and the employer ideally would have workplace policies that deals with complaints and grievances. But in relation to the positive obligation, my understanding is that it falls on the employer to take positive obligations in relation to sexual harassment in the workplace.
Yeah, that's right. So but it is something that you need to empower all of your team members to become a part of. There is some bystander obligations that have been placed, and that's also to make sure, but it falls back onto the employer, or as they term it in work health and safety, is the person conducting business.
And I think this also sort of circles back on providing information to your employees as to what sexual harassment is, and all this sort of stuff, to educate them if any sort of situation ever arises.
Yeah. Okay, so thank you. We've gone over time today, but hopefully we've answered a lot of your questions, and you've got a little bit more guidance on what you need to do to make sure that you can address these changes that have been made. And as you know, we are a resource available to you if and when you need. So get in touch with us and we can help you out. But thank you very much for taking the time to sit through this today. We hope you got something out of it, and we look forward to seeing you next time. Thanks very much.
Thanks, guys. Thanks for coming.